You have absolutely no issue with me recording this conversation, do you?
No, sir.
So, a quick Google search will bring up the Illinois compiled statutes for domestic violence. And I was informed by Lucas Poor that a lieutenant had made his decision and that was, all that he could do. Apparently, upholding the law based upon opinion goes against um, the actual facts. Are you familiar with domestic violence law?
I am, sir.
Okay, so if a stepson is involved in the harm of another human being, does that count as domestic violence?
Who is the other human being?
Me, if it was a stepson.
Are you wanting? I guess let me preface with any answer I give you. Are you trying to quiz me on my knowledge of the domestic battery statute?
I'm just questioning you on your knowledge of the law.
Okay. Well, just like anybody else, I know a lot of the law. I can look up anything that I don't know specifically.
Well,
I guess let me ask you this: What is? I don't understand your angle or
would you mind looking up um, who is guilty of committing domestic violence in a situation, you know, relatively pertaining to me on the night of January 20th, um, whom all should have been arrested on the night of January 20th for domestic violence based upon the letter of the law, not based upon opinion, not based upon, well, my superior told me that this was how we were going to proceed, but based upon the letter of the law that I'm asking you to look up now, who should have been arrested?
Sir, I'm not gonna tell you who should have been arrested. A decision was made at the time of the incident. It has been looked at multiple times. I assume the lieutenant that Detective Poor is referring to would have been Lieutenant Thompson. Uh, there have been people multiple times have looked at the case and decided whatever it is that they have decided. If no further arrests have been made, then that was the decision that was made. If you feel that you've been wronged or you have a complaint against the police department, you are more than welcome to make that complaint.
I am making that complaint right now.
You can come up to the police department
I am not coming
without.
up to the police department because I came up to the police department once already under Miranda rights and was questioned by Lucas Poor for 45 minutes. And,
About this case?
oh, yes.
Okay. Right, and see, you're talking. Like, if you were under a Miranda, that would mean that you're being asked potentially incriminating questions.
Exactly.
Yeah.
And I
So
walked out of that interrogation um, without being placed under arrest. So a person commits domestic battery if he or she knowingly, without legal justification by any means, causes bodily harm to any family or household member. That's subsection A, subchapter 1, or subchapter 2 makes physical contact of an insulting or provoking nature with any family or household member. That's
right,
that
that's the
that's part
definition
2.
of domestic battery according to the Illinois compiled statutes.
Okay. So what are the definitions of family or household member. Do you know that? This is
I couldn't tell you all off the top of my head.
okay.
There's
I can tell
a
you.
lot.
I can tell you. Would
I can
you
look it up and read it to you if that's what you're wanting.
would you like to do that for me?
I wouldn't like to, no.
Well, would you?
Would I? Sure.
Okay. Please read that to me.
All right, give me just 1 second. Make sure I have them all. All right, are you ready, sir?
I'm listening intently.
The definition of family or household members, according to the Illinois compiled statutes, includes spouses, former spouses, parents, children, stepchildren, and other persons related by blood or by present or prior marriage, persons who share or formerly shared a common dwelling.
Wait, pause for a moment.
I'm going to finish. No, sir, I'm going to finish the definition. Persons who have or allegedly have a child in common, persons who share or allegedly share a blood relationship to a child, persons who have or have had a dating or engagement relationship, persons with disabilities and their personal assistants, and caregivers as defined in Section 12-4.4a of the Criminal Code of 2012. For purposes of this definition, neither casual acquaintanceship, nor ordinary fraternization between two individuals in business or social context shall be deemed to constitute a dating relationship.
Okay, so now can I ask a question?
Yes, sir, you may.
If I was married to Dottie Fricky, which I still legally am, correct? And her son, well, two of her sons that are not my children, but her children, would they be related to me by blood or marriage?
They would fall under family or household members.
They would be related to me by marriage, correct?
Correct, sir.
Okay. As well as Dottie's nephew, Jaden Miley, correct? He would...
Could you repeat that last part? I apologize. My radio was going off.
Would Jaden Miley, which is my current wife's nephew, be related to me by blood or marriage? He would be related to me by marriage.
He would be related to you
by marriage.
If you could let me finish, sir. By present marriage.
Okay.
Now, I'll say that the definition under domestic violence statute, like compiled statutes, doesn't specifically mention nieces or nephews. It doesn't really go beyond the scope of children. Sir, let me finish, please.
All right.
It doesn't go beyond the scope of children and stepchildren, but I will tell you, it does say other persons related by blood or present or prior marriage.
Okay, so we have Gavin Miley, we have Darian Miley, and we have Jaden Miley, correct? Mm-hmm. Gavin Miley and Darian Miley are brothers. Jaden Miley is their cousin, which is my wife's nephew. Anytime that there is a situation where two or more attackers incapacitate another person, what does that fall under? Does that fall under gang violence, or does that fall under mob action in the state of Illinois? I'm asking a question. There is no reason to question me back. This is your purview, your field of knowledge, and your expertise that I'm asking. Anytime.
That would fall under mob action statute, sir.
Okay. So I'm just seeking for my own knowledge. I've been told multiple times. This is my sixth or seventh time trying to facilitate justice from obviously a partisan police department as well as a state's attorney. According to the letter of the law, based upon my injuries on the night of January 20th, I obviously didn't do those injuries to myself. I tried to press charges that night, and I've tried 6 or 7 other times, including this moment right now, to have the individuals that caused said harm to me arrested. And at every point and turn in this situation, I have been informed that the case is closed. Now, you just read the law concerning domestic violence, and you just told me that any time that there is a situation that there is 2 or more against an individual, that it would be mob violence, correct?
No, that is not correct.
What did you say that it was then?
I did not tell you that any time that happens that it is mob action.
So refresh my memory as to what you stated.
You asked me if those 2 individuals attacked you, one single person, would it fall under gang violence or mob action, and I answered mob action.
Okay, so we will go with 2 or more people being mob action, correct?
Yeah, when they act together, yeah.
Okay, so 2 brothers and a cousin acting in concert to
Jacksonville Police Department, 1027 for a bike. 28 for a bike.
incapacitate me in an attempt to disable, if not kill me, would be construed as mob action, correct?
If there are no other extenuating factors, circumstances, anything else applicable to the incident, if those 2 or 3 people came together and acted together to incapacitate you, cause you great bodily harm, then that would fall under mob action, yes.
Okay, so based upon the testimony of my own wife on the night of this incident, and based upon the combined statements that were not independently gained, because everybody that was in the house stayed in the house and everybody was questioned within the house, and they all gave, because they were related, collaborative stories that all backed each other up. There was no independent questioning of each individual person. You have a one person, which would be me, versus multiple parties, which was everybody in the house, and my wife's statement, Dottie Fricky's statement, was that as soon as Gavin Miley walked in, which he was the first on the scene, as soon as he walked in, I put my hands in the air. Have you had an opportunity to review the case at all?
No, sir. I have not looked at that case.
Oh, I would definitely review the case because I've looked at it time and time again, which is the reason why I've called time and time again. Because by their own statements, as soon as Gavin Miley arrived on scene, I put my hands in the air so as not to be construed as anything, violent or misshapen, misinformed, whatever that you would like to call it. And then I was senselessly beaten within an inch of my life by 3 individuals. I would just like to know why the actions of the police department in Jacksonville, Illinois, contradict the letter of the law in Illinois solely based upon a lieutenant's discretion. The letter of the law is clear.
Are you telling me that the letter of the law is clear, or what are you asking me about it?
I'm explaining to you what the letter of the law is, and I'm asking you to explain to me why it wasn't upheld.
I can tell you that the decision was made on scene, right?
Okay. Who made that decision?
Who made the decision to write the citations and do whatever was done?
Yes.
That would have been me, sir.
So you made the decision to disregard the letter of the law and arrest everybody based upon your what?
Sir, if I could refresh your memory, you had zero interest in telling me anything about me or my officers telling us anything about what had happened.
Okay. So let me refresh your memory. The only time that I was given an opportunity to state my case was after I was placed under arrest.
I would disagree with that statement.
Bring up your body camera footage, review it, and then argue with me. Because
We did not have body cameras at that time, sir.
dash cameras, bring up any available video footage. Now, had my wife not deleted the video camera footage that was inside the house, that would have recorded and been evident for everything concerning proving your case against me or disproving your case against me. But my wife deleted that. I have tried on multiple occasions to retrieve the video, and my wife has admitted to deleting the video. And yet, I'm out here as a victim of domestic violence and mob action and aggravated battery with intent to do great bodily harm because Jaden Miley used a taser upon me, and I was stomped and punched about my head, neck, and upper torso. And as recently as March 23rd, Gavin Miley had made a post on social media that said, "Matt Fricky, not only are you scum for touching my mom, you're also dumb for thinking her grown-ass sons and nephew," sons being plural, "wouldn't be there when we got the call. You deserved a lot more than what you got that day, and I hope you rot in prison before you're able to terrorize another woman. So, that right there indicates a knowledgeable acceptance and admittance in participation in the crime against myself. And time again, law enforcement in Jacksonville, Illinois, and within Morgan County have refused to act upon every bit of evidence that I have provided.
Well, sir, I can tell you that it is not my position to challenge your rights. It is not my position to...
All that I was asking was that
All I'm asking, sir, is that I let you speak. I don't interrupt you. If you could do the same for me.
That's fine.
Thank you. It's not my position to challenge your rights as a citizen of Jacksonville and a potential victim of a crime. I'm not saying that you're wrong for looking into this. I'm not saying anything of the sort. What I am telling you is that you are correct. You have called up about this incident multiple times, and it has been passed down to our detectives division. They have looked at it, and if their decision was that the case is closed, that is where it lies. If they've passed information to the state's attorney's office and they've reviewed it and decided not to press charges, that would be where it lies there. I'm not going to open up a new call on this based upon...
So let me pose a hypothetical situation and get your input on it.
Sure.
So let's say that I have a vacation home in Florida, correct?
All right.
I go to Florida, and I'm there for a week, a month, 2 months, 6 months, however long I decide to go to Florida, and I'm there. While I'm in Florida, my property in Illinois is vandalized, whether it is burgled of all valuable content, whether it's burnt to the ground, whatever. I arrive back in Illinois and I want to press charges.
Okay.
Say that I'm in Florida for 6 months. I come back to Illinois 6 months. This happens the day after I leave. I come back to Illinois 6 months to the day after my property has been damaged and burglarized, burnt to the ground, whatever the case may be. I come to the police department and I want to file a charge. I am willing to provide the names and information that I know pertaining to the individuals that did the damage to me because I had them on video camera. Are you explaining to me now that me coming 6 months later would constitute you having opened, looked into the case, and closed it based upon your investigations?
No, in that hypothetical situation, had you not come back and spoken to anyone about it, there never would have been a case open to begin with.
Okay, so as a person placed under arrest, what are their Miranda rights?
Do you want me to read Miranda rights to you?
I'm perfectly game with listening to it because I have nothing better to do on a Saturday night.
Well, sir, I do have better things to do on a Saturday night than read you Miranda rights. Which
Oh, so you're not willing to read what my Miranda rights are to me for the record?
For what record, sir?
My personal record.
Your personal record? And then personal record, and then you're recording me right now?
Yes.
Okay, you didn't advise me that you were.
I did advise you. I asked you when I first started this.
You asked if I mind. You didn't tell me you were. You did not make me clearly aware that you were recording me.
No. So how would you like to proceed?
I told you I would not mind being recorded. You did not inform me that you were recording me, though.
No.
You're wanting to be informed of Miranda rights, right?
Yes.
Okay. Do you want a history of the Miranda rights? Do you know what case law the Miranda rights come from?
Well, sure, if you've got that much time.
I don't, sir, actually. There's other things going on in the city, but it comes
I know. I heard the sirens earlier, and that's why I waited to make my phone call. And I was hoping that just a simple officer would suffice in resolving my issue. But he was very negligent in his willingness to understand the law and what an individual's rights are. And upon my pointing out that, there are situations where there can be more than one victim, dumped me on your lap.
Okay. Well, I can tell you, it's a Supreme Court case, Miranda versus Arizona. That's where it came from, and your Miranda rights basically tell you what your constitutional rights are. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. That basically encompasses all of it.
So you understand that while I was standing out at the ambulance on January 20th, when officers walked up to me and said, "Mr. Fricky, we're arresting you for domestic violence," and put handcuffs on me, then they asked if I was willing to, tell my side of the story, and I chose to what's the catchphrase of the day? Oh yeah, I chose to shut the fuck up as soon as the handcuffs went on me and I was told that I was under arrest. At subsequent intervals since then, I have tried to press charges against the individuals that battered me. Hell, I've even tried to press charges against the state's attorney for inappropriate conduct because he was conducting official business via his personal cell phone. And the individuals involved in the Good Old Boys Network, which resides within Morgan County and the Jacksonville Police Department, have disregarded every aspect that I have ventured down. I filed for my divorce on March 20th or 22nd. And I just got served divorce papers from my wife that were filed May 31st. By the same judge that dismissed my motion to dismiss the entire charge of domestic violence because my wife was having interpersonal communications with the state's attorney. So on my 45-ish minute interview with Lucas Poor, I provided him paperwork. I believe I sent you personally an email containing some of the contents of the information that I have. And yet you still have chosen to do nothing. I was trying to think of something that you guys have done to protect another citizen's rights, but apparently the protection of the rights only extend to the females in Morgan County. Is that correct?
I would disagree with that statement, sir.
The facts that I have in my possession and the evidence that I have in my possession scream to the far end of your argument. This is literally my 6th attempt to obtain justice, and at every attempt that I have made and all of the evidence that I have provided, everyone, including yourself, has told me, "Oh, we've already closed the case."
Let me have you hang on just 1 second, sir. I have to handle something with my officers real quick. Mr. Ricky, I apologize for that. Where were we?
Oh, I was starting to be a little bit concerned about my recording of this conversation. And it boils down to whether or not I called you from my own personal residence or I called you from a bar or a public library. Both of those instances have video cameras which would have been recorded without your consent or mine.
You talking about eavesdropping law?
Well, yeah, because I initially had asked you if you had any problem with me recording the conversation, and you said that you didn't have any problem.
That's
But
correct.
you didn't consent positive or negatively, so I inferred that you didn't have a problem was your okay.
Sure. I'm not raising an issue with this, sir. I was just letting you know. According to eavesdropping law, you need to people, those parties need to be aware, right?
Well, I advised you at the very initial, aspect of it.
No, you asked me if I would have mind. I indicated that I would not mind being recorded, but you did not inform me that you
So, if I can provide evidence of the state's attorney for Morgan County engaging in official business for, representing the county of Morgan on his personal cell phone number, does that make his personal cell phone records available to the public, according to case law?
Give me just 1 second, sir. I apologize.
That's fine.
10-4, hold down. Get that in a moment if no one else handles it. I do apologize. You said if he's using his personal cell phone to conduct official business, what was the rest of the question?
If the Morgan County State's Attorney is using his personal cell phone number to dispense legal advice and conduct official, state's attorney business, does that make his personal cell phone records available to the public?
I don't think it would be like. Okay, let me make sure I word this correctly. Now, let me preface my answer with, I can't sit here and recite FOIA law or information to you. I have a general understanding of what I would call a decent understanding of FOIA, but if I say something that is incorrect, it is not intentional to deceive you in any way. It's just I might have misspoken or might be incorrect in my understanding. However, if whatever device is being used to conduct official business from a public entity, law enforcement, state's attorney, what have you, I do believe whatever the connection may be, it could be FOIA-able, subject to FOIA, Freedom of Information Act.
No, that just kind of screws the fucking state's attorney.
I guess if he's done something wrong and there's evidence of that and it's able to be FOIA'd, then that's
presented.
On the I don't work for him and he doesn't work for us. So.
I presented that information to Mr. Poor himself. I gave Mr. Poor a folder containing detailed information on the misappropriation of information, where my wife was somehow given the state's attorney's personal cell phone number, and she was questioning him as to whether or not something violated an order of protection. And he in turn sent her a text message saying that he did not believe that an individual could revoke license plates, that was only at the discretion of the Secretary of State. And I looked into the matter in depth before I revoked the license plates on my 2021 Chevy Spark. And I was informed by the Secretary of State that if a vehicle is licensed and titled solely in my name, that if I did not have possession of the car and that car was involved in an accident, that I could be held personally liable, which is the reason why I revoked the plates. My wife has a substance abuse issue with alcohol, and I was not willing to be on the hook if my wife injured, killed, or maimed somebody, so I revoked the plates. So, what is it? Class A misdemeanor is what the state's attorney would be guilty of.
For what?
I'd have to look it up. I've looked up everything.
I guess let me ask you this: what what issue do you have with the state's attorney communicating via a personally owned cell phone or a Morgan County owned landline?
Okay.
Like for example, I
the-
apologize, I don't mean to interrupt you, but let me just ask. I just want to add a caveat off that. For example, had I called you back from my personal cell phone, would you have found issue with that?
Yes, because that would have made your personal cell phone subject to a Freedom of Information Act request, because I'm conducting official business. I'm trying to contact a law enforcement officer, and I'm not trying to conduct business with a person. Like, people have business phone numbers for a reason. The Morgan County State's Attorney has a business number for a reason. Correct?
They have a number, yes, you can call their office.
So unless my wife had personal relations with the Morgan County State's Attorney prior to the incident that occurred on the night of January 20th, 2023, that would constitute inappropriate conduct on the behalf of the Morgan County State's Attorney. And I can assure you that my wife had no such contact with the Morgan County State's Attorney prior to January 20th, 2023. I paid the cell phone bill. I know who she talked to.
Okay.
So anything post January 20th, 2023 would constitute biasness and impartialness, or partialness, I should say, on my wife's behalf and on the state's attorney's behalf. So when I have charges being filed against me, and I have a conflict of impartiality, and I have officers as well as sergeants, lieutenants, and, chief of police, I don't know how far up it goes, unwilling to follow the letter of the law in lieu of their opinions of what happened that night. Do you see where I have issues and complaint?
I see where you have a lot of issues. Sure. I think that if you're saying that there's a biasness or an impartiality on behalf of the state's attorney, that would be a motion you would have to bring up in court for your case.
I've already got the ball in motion on that aspect, and I've already talked to someone on this shift that was higher up than you, or maybe it was you. Hell, I don't remember. I've contacted the FBI, the Department of Justice. I've contacted every outlet except the news media, and I have a Google folder full of the information that Jacksonville Police Department has refused to do anything with, which is a shareable link, which is weird because, you would think that law enforcement would be interested in, upholding the law. And I'm just trying to figure out why you're not. Is it solely a targeted agenda against myself? That the law is disregarded to the letter because I have made such a wave and such a strife in the goings on of the corruption of Jacksonville.
Is that you're asking me? As
Yeah,
far as I know, you
yeah.
haven't made any wave or strife in the goings on of Jacksonville.
So
Not to my knowledge.
I'm trying to figure out why the law is not uniformly applied. Why is
Sir, I can't make it any more clear. Is that that the decision was made on scene. That decision has been reviewed. The statements made, all the information that we have available has been reviewed. It has not. There's been no further arrest made from the case. Calling and expressing your dissatisfaction with that decision to me doesn't change that.
okay? So what you're saying is if I was in Florida and I got robbed in Illinois while I was in Florida, based upon the current police policies in Jacksonville, is the Jacksonville Police Department would do their investigation, and even if I was able to provide photographic evidence to the contrary, once the Jacksonville Police Department has conducted their investigation and said, well, we can't find anybody that did anything, the case is closed. Is that what you're saying?
No, you're asking me to you're asking these questions, and they're awfully loaded questions. You're saying, is it the policy of the Jacksonville Police Department to do X, Y, or Z? And I believe your goal is for me to say yes.
I'm not asking one way or the other. I'm just asking for a truthful answer because at multiple instances a crime was committed against me by 3 individuals where I suffered injuries which has caused me to have seizures, and you're telling me that we did an investigation, but because of your unwillingness to provide a statement at the time, we closed the investigation with no wrongdoing on any other party's part except your own. So if I was in Florida and I was robbed in Illinois, say I had a warehouse in Illinois and it was robbed, the Jacksonville Police Department, well, nobody was here as a witness. We'll just chalk this up as it's a closed case. We don't know anything. Then 6 months later, I came back to Illinois and said, look, I've got photographic evidence of the people that fucking robbed me. I've got text messages from the people that robbed me. You guys are going to still tell me, well, we closed our investigation, so, good luck.
No, sir, no. If that was the case, that specific case, number one, it would be a burglary, not a robbery. But if your residence, warehouse, what have you, was burgled, and you came back 6 months later with all this evidence, it would be investigated. Now, let me tell you that when you call up here and it's been passed on to detectives, they look at the information. It's not someone. It's not. I'm not just sitting here telling you. You know what? No, it's 6 months later. I don't want to look into this. We're done here. I'm telling you that all the information you have. You've come in. You've talked to Detective Poor. The information has been looked at, and the decision has been made that there won't be any further arrest made.
Who makes that decision?
If Detective Poor told you that it was a lieutenant, I would assume it would have been Lieutenant Thompson. I cannot speak on his behalf. I cannot speak to his decision making. I cannot speak to what Detective Poor told you. I wasn't present for those conversations, correct? So what I can tell you is that if you are dissatisfied with the decision, you are more like I can print you a complaint form if you want to file a complaint. It sounds a lot of your complaints aside from the investigation of this matter, seem to pertain to the state's attorney's office.
No, my biggest complaint is the fact that I was beaten by 3 people within an inch of my life, and I'm basically a laughingstock by the police department when I have provided, even in this phone call, evidence.
I haven't laughed at you, sir. I have not laughed at you. Please don't say that.
I'm not saying that you personally have laughed at me. I said that I'm feeling like a laughingstock because of the injuries that I provided or that I suffered, and I've provided information pertaining to how I obtained those injuries, and I'm being told, well, we've conducted our investigation and we issued tickets for what was it? A city ordinance violation for fighting, when those city ordinance violations for fighting should have been arrests for domestic violence. Because I was beaten within an inch of my life. Officers that brought me into the Morgan County Jail were questioned as to why I was the only one being brought in. My sister, who was on the phone at the time, was questioning why I was the only person being arrested. Like, she was on the phone with me while I was in the ambulance. Yet I was the only one that went to jail. So that all falls on one person's head. And by that accountability and by your own, admission, that was your call. So I would like to know from you what your personal beef against me was, to where I was the only one arrested and no one else was for domestic violence. I was accused of putting my hands on my wife. As soon as anybody walked in the house, my hands went into the air so as not to misconstrue anything that was going on in my house as otherwise. I was beaten within an inch of my life. My medical records, as well as my booking photos, prove that. And now I'm being told, this is the 6th time, that, well, we made our decision based upon the evidence that we had in hand, and you didn't make a statement at the time. I didn't make a statement at the time because I was placed under arrest. And when you have the placement of arrest placed upon an individual, that individual has the right to remain silent until he has counsel present. I chose to remain silent until I had counsel present. I didn't have counsel present, so I stayed quiet.
You made that choice, sir.
I made that choice after I was placed under arrest.
Right, your Miranda rights are there. You have the right to remain silent, meaning that if I ask you a question that you don't want to answer because of whatever reason, you don't have to. It does not mean you have to invoke those rights entirely. It doesn't mean you can't give a statement. They're not all. It's not one or the other. It's not.
No. It is one or the other because
no,
you.
No, sir, it's not.
No. Your understanding and my understanding of the law are apparently two different things, because I understand.
You are perfectly capable of giving a statement without answering any questions.
Okay, once I'm placed under arrest and then I'm told, well, you can tell us what happened. Once my wrists are behind my back in handcuffs and I'm told that I'm placed under arrest, anything that I say can and will be used against me in a court of law. Is that not correct?
That is correct.
Okay.
Let me say this. If you are placed under arrest and your statement would be contradictory to what information we currently have you under arrest for, it is just as easy to not have you under arrest from that point forward. You have the right to not answer any questions. You have the right to not make any statements whatsoever. That is your right. That is your choice. That is not telling you can't make a statement. We're not telling you that you can't answer questions. We are simply advising you that you have the right not to if you choose that right.
Okay.
We're advising you that if you make a statement that would deem you to be guilty of a crime, any statement whatsoever, it can be used in a court of law. That is not saying that you can't make any statements or answer any questions.
Okay. So, with that being said, I had at my house at 120 North Prairie a pet recording camera that was Wi-Fi capable as well as recorded to an SD card. Once I was placed under arrest, before I was ever questioned about anything, because all of the parties involved on the inside of the house, which was Gavin Miley, Darian Miley, Jaden Miley, Eva McNeese, Dottie Fricky, all of those people were in collaboration on getting their stories straight. The camera that sat on my hutch in the living room at 120 North Prairie recorded everything. I have text message printouts as well as the live text message itself, copies of the conversation where my wife admitted to deleting the video, not because there was anything, damning towards me on there. She deleted it because, by her words, I was walking through the house yelling at her and she was topless. So, do you think I would disclose to the police anything along those lines, given my history, about that video?
I can't speak for you, sir.
I can tell you right now that I wouldn't, because what is the rule number one? Have you ever watched Andrew Fleshy on YouTube?
No, sir.
He's a pretty good, goofy-looking lawyer that's out of South Carolina, Washington, somewhere over there. And there is not a person on YouTube that's, tells you that when you're placed under arrest, always talk to the cops. Everybody explains across social media platforms, regardless, that once you're placed under arrest, your duties as an arrestee is to shut the fuck up. And I'm old enough to understand how valuable that is. However, you're explaining to me that my option to shut the fuck up once I'm placed under arrest involuntarily excludes anybody that committed any crime against me because I didn't speak up when I was placed under arrest. I'm just trying to figure out where the logic is in that, because once I'm placed under arrest, I'm going to shut the fuck up. And I know that by statute and by law, I have 3 years to file charges against the people that battered me. And you're telling me this is the 6th time that, Oh, yeah, well, since you didn't make a statement that night, yeah, you can't file charges. I'm telling
That's not what
you,
I'm saying.
I'm telling you
That is
that
not what
I
I've
want
said.
to file charges against the individuals that battered me, and you're telling me, well, we already closed the case. It's already been reviewed. Apparently, these people didn't do anything to you. You wound up with those injuries on your own. I want to press charges against the individuals that battered me. I can provide you with the evidence that these individuals have admitted to battering me. And you're still telling me, yeah, we're not going to accept that because you didn't say anything on the account when you were first arrested.
Again, you're misquoting me.
Well, you've told me time and time again throughout the past hour and 56 seconds that I have no grounds and that your officers and whomever have reviewed it and investigated it and blah, 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 and that, yeah, we've done our due diligence. You have no leg to stand on. I have booking photos as well as the photos that I had taken of myself when I got bonded out of jail, as well as my medical records as soon as I went to the fucking hospital after I got out of jail, as to the fact that I obtained those injuries, not in the county's custody. I'm just trying to figure out what it is that I need to do to have legitimate charges placed against the individuals that caused me the harm that occurred to me on the night of January 20th, because the law is quite clear on domestic violence. And you're telling me that, oh, well, we did our investigation and they didn't do anything wrong. Well, that's not what the law says. The law is quite clear. The law is not based upon a sergeant, an officer, a lieutenant, a captain. Unless you're a part-time Supreme Court justice as well as a sergeant, you can't make that call. Following the letter of the law is the job that you were sworn to uphold, correct? So why is the letter of the law not being followed in my case?
Sir, I really don't know how I can make this any more clear. A decision was made.
Who made that decision?
You're going to ask the same question again, sir? I answered that already for you.
Who made that decision?
My officers talked to everyone there. They came to me. We talked about it. The decision was made by me to follow through how it was settled at the time, with what information we had at the time. Now, if you've come up here and wish to provide more information, you've expressed interest in wanting to pursue charges against other individuals, and if that was then investigated and deemed that there would not be an arrest made, I mean, if my decision making at the time on scene was incorrect, then it was incorrect.
I
made a decision.
Your decision.
I made a good faith decision on what to do with the situation.
Your decision on scene was incorrect, according to the letter of the law.
Okay.
So I'm talking to the person that made the fouled decision, and I'm getting rebuttal from the person that made the fouled decision to justify his actions. Nothing personal against you, but
how am I trying to justify my actions, sir?
Well, you're not willing to follow the letter of the law and you're justifying your standpoint. The letter of the law is clear on domestic violence.
Sir, respectfully, I am a patrol sergeant, okay? We handled the incident as we did at the patrol level on scene. You have come up and made your complaint about wanting to pursue charges. That has been investigated by, it looks like, Detective Poor. And if no arrest is going to be made, then no arrest is going to be made. That is beyond
Detective Poor's exact commentary, well, not verbatim, but he explained to me that unless he can get any one of the parties to admit to battering me or assaulting me, whichever, whatever, that can't go forward, and they're not willing to do that until the investigation against me is over with.
Right, and that,
So
that is beyond my scope as a patrol sergeant, right? If Detective Poor,
do you understand how absurd that sounds?
I can understand why you're saying that. However, I don't know the basis for him saying that. I'm not a detective in our investigations division. I don't know what parameters he's working under if that is the case. I can tell you that if you have called up, you have talked to Detective Poor, there is a case for that. Now, if he is not making an arrest on it, then that is something you would have to talk to him. I can't speak for him.
I'm not asking you to speak for him. I'm asking you to speak on your knowledge of the law and of law enforcement as you understand it.
And I'm telling you, I don't have an informed decision for you to that as of right now. I would have to talk to the detectives and find out why that was what you were told.
So
I'm not going to misspeak and make assumptions.
I'm not asking you to misspeak. What I'm asking you is to listen to me for another minute and a half.
Okay.
And the law.
I'm trying to monitor a couple sport bikes.
The law in Illinois states that if a superior makes a wrongful call, shall we say, that it is up to the officer or officers involved to go over said supervisor's head to whatever discretionary options that are available to them. I understand through my processes of learning how Jacksonville Police Department works that Jacksonville Police Department doesn't have an internal affairs investigation team. And it all falls, within the county brotherhood of individuals where everybody backs everybody else.
I believe that chief might be.
And I'm not okay with that.
What gives you the impression that Morgan County handles any of our internal investigations?
I'm speaking of Morgan County in general as Morgan County, Jacksonville Police Department, the state's attorney's office, the judge, I'm speaking in a generalized terminology.
But we don't have a specific internal investigations department. If a complaint is made or an investigation upon one of our officers needs to be done, it's conducted by the appropriate supervisor or investigative authority within the department. We're not talking about an enormous department here, right?
I know. We're talking about a good old boys department where everybody gets together and plays golf or goes to the same bar or whatever. And, hey, bro, I got your back. It's the same with a police department as it is with a crew that works at fucking Reynolds Consumer Products.
Yeah, I would disagree.
Everybody covers each other's ass.
I would disagree.
I wouldn't.
And that's your opinion, sir.
I have bore witness to the situations and circumstances involving Jacksonville Police Department for over 20 years. I understand how the game works.
Give me just 1 second, sir. Still there, sir?
Yep.
Okay. I don't want you to feel cheated on time by any means. I can tell you I cannot stay on the phone much longer. I know that you're saying it's a good old boy system. I would disagree. But
If it's not a good old boy,
I'm telling you that I made the decision. If I erred in that decision, then I erred in that decision. Like I said, you are free to file a complaint. You are free to come up. I can tell you that Detective Poor has opened a case for your complaint. I don't know any of the details of where it's going, where it's at. I'm not involved in it, but I can tell you it's open.
So allow me to ask you this. Is Lucas Poor higher ranking or lower ranking than you?
In terms of hierarchy of the police department, he is lower ranking than me. In terms of their different divisions, he is a detective. I'm not a detective. I'm at the patrol level.
So
But in terms
that
of
would explain why why you know about his investigation. So when everything that you looked up concerning anything that I stated revolving around his investigation of this,
I have no idea what you said to him or about the investigation. I have no clue.
but you can squash his investigation at a moment's notice.
No. I'm not his supervisor.
There is absolutely zero accountability for the Jacksonville Police Department.
Incorrect, sir. If you have a complaint, I would encourage you to come get a complaint form, sir. You keep making these broad accusations to me on the phone about everything that you've said. If you want to file a complaint, I would encourage you to do so, sir. But right now, I have an obligation to my patrolman. I can't stay on the phone much longer. I've tried to give you as much time to be respectful of your time as well. And if there's any questions you still have that are unanswered, I do apologize.
All right. Have a good night.
Okay? You too, sir.